Hello everybody, welcome to iExamB. Embrace your iExamB learning experience. We have moved to part 10 of our legal maxim series. So far in the 9 parts we have discussed around 45 to 50 legal maxims and I hope you have revised them, you have learned them. These are the most important legal maxims. Starting with the part 10, the first legal maxim today is de jure. This means by right, also known as by law. It is used to describe a practice that exists by right or according to the law. There are two terms, de jure and de facto, which have slightly different meanings. Something is de facto if it exists in practice or actuality without being officially established. Therefore, de facto recognition is referred to as the recognition that is based on fact, whereas de jure recognition is referred to recognition that is only based on law. So the second legal maxim is de facto, which is in fact. De jure describes practices that are legally recognized, regardless of whether the practice exists in reality or not. In contrast, de facto describes situations that exist in reality even if not formally or not legally recognized. The next maxim today is de novo. This means starting afresh, or it can also be referred as from the beginning. When a court hears a case de novo, it is deciding the issues without reference to any legal conclusion or assumption made by the previous court to hear the case. An appellate court hearing a case de novo may refer to the lower court's record to determine the facts, but will rule on the evidence and matters of law without deferring to that court's findings. A trial court may also hear a case de novo following the appeal of an arbitration decision. The next maxim is de futuro. This means in the future. This legal maxim is often used in reference to a promise of marriage that was not binding if it mentioned marriage at a future date. One example of de futuro is a promise between two people to get married in 5 years. This promise is not legally binding because it is referring to a future event. And another example is a contract that states a company will deliver a product in 6 months. This contract is de futuro because it is referring to a future time. The next maxim is de integro. This means as regards the whole. De integro also means to do something again or second time. In other words, often it is used to mean start it all over in the context of repeat de integro. The next maxim is de die in diem. This means from day to day. It refers to something that applies on a daily or day-to-day basis rather than over a long period of time. It is used in reference to contracts, leases, employment terms, or other binding agreements where certain elements are variable or flexible on a daily basis rather than predetermined. For example, compensation that is based on a de die in diem basis would fluctuate daily based on hours worked, units produced, etc., rather than being a fixed salary. Similarly, a rental agreement could allow for rent payments to be calculated on a de die in diem basis depending upon occupancy rates or other variable elements. The next maxim of today is de minimis res non curat. This means the law does not notice trifling matters. In other words, there is a threshold beneath which the law, in all its intellectual might and procedural majesty, does not deign to concern itself. In a lawsuit, the de minimis doctrine is applied by the court to avoid resolving trivial matters that are not worthy of judicial scrutiny. Its application sometimes leads to the action being dismissed, especially when the only redress being sought is for a nominal sum. It is a principle of common law that stipulates that judges will not sit in judgment or take notice of extremely minor violations of the law. In accordance with this maxim, rational citizens would consider an appeal for trivial matters to be a complete waste of time and resources. It will bring disrepute to the judicial system. Coming to the next maxim, dictum. This means statement of law made by a judge in the course of decision but not necessary to the decision itself. In one of our earlier videos, we have seen obiter dicta, which are passages in judicial opinion not necessarily for the decision of the case before the court. Such statements lack the force of precedent but may nevertheless be significant. Dictum is that statement of law which is made by the judge in the course of coming to the decision, but it is not necessary to be the decision itself. So these were all the legal maxims in part 10. We have discussed a little bit more legal maxims because they were quite similar, de jure, de facto, de novo. So I wanted to give you all these maxims in a single slide. Take a screenshot, revise these legal maxims, and keep on practicing for your upcoming SEBI Legal Phase 1 exam. If you need any form of guidance, preparation material, mock test, section test, test series, you can check out our SEBI Legal Quick Revision course. You can also check out our various other courses which can help you in the preparation of upcoming law officer exams. That's all for now. Thank you so much for watching this video. Enroll with iExamB and make your preparation 50% faster. Subscribe to our channel. Stay tuned.